thank you to all of you who are participating from, it looks like, all around the country. Thank you for those lovely welcome notes. It's wonderful to hear where you're from and to see your names, and welcome, welcome, welcome to you all. Today, we're going to talk about effective protection orders for immigrant survivors. I want to begin by introducing myself, and then I'm going to ask my fellow panelists to introduce themselves. I'm Laura Livingston. I'm a senior judge. I live in Travis County, Austin, Texas, and senior is a designation in Texas that means I was on the bench for a very long time. I'm old enough to retire. I did retire, but I'm also sitting by assignment, and so I'm still actively hearing cases on a regular basis. Judge Collins.
Good afternoon, everybody. It's a real pleasure to be here. I am Judge Rosemary Collins. I'm a retired judge, a really retired judge. So I don't hear cases anymore, but I do get an opportunity to travel and to do trainings all over the country. During the 30 years that I was on the bench, I was the presiding judge of our family division. I was the presiding judge of our coordinated courts division, or domestic violence courts, which included the civil courts that dealt with domestic violence, family matters, and the criminal courts that dealt with that. I also had a full-time felony caseload, and I've heard thousands and thousands of orders of protection. We were a national mentor court in our jurisdiction for our domestic violence practices, and I did a lot of work on immigration law, and that's how I got connected to Professor Leslie Orloff, who I'll turn it over to now.
Welcome, everyone. I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law. I'm very happy to be here. I started my career doing protection orders. I was the first Spanish-speaking lawyer in DC who knew what a protection order was. And very happy to be here today and share with you information about the particular issues that are important for immigrant survivors and protection orders. So, and I've been doing work on immigrant victims and protection orders and other immigrant victims' legal rights for about 40 years now. So this event has been sponsored by the Office on Violence Against Women and the State Justice Institute. What you will hear today are the opinions of our faculty and do not necessarily reflect the opinions of the Department of Justice or the State Justice Institute. We also want to note that this is a training in which we have a number of slides. That our slide deck is a bit broader than what we'll be covering here today. We did that on purpose. We wanted you to have checklists available and information available to use as a resource following the webinar. Judge Collins, would you mind telling people a little bit about the network as we get started?
Right. So I'm a member of the National Judicial Network, as are hundreds of fellow judges from all over the country. In this network, we focus on human trafficking issues and immigration issues in the state court. This is a great network to be part of because we have peer-to-peer sessions where you meet with your fellow judges who have concerns and interests in this area. We meet with experts from all over the country that can talk to us about areas that we're particularly interested in, keep us up to date on the latest information. And we have webinars that are training webinars that are issues related to trafficking and immigration in state courts. So the best thing about it too is that it's free. So you can join, you can learn, you can socialize and communicate with other judges and other people who are involved in this area. We have great trainings. I really urge you to become a member. It's been a wonderful asset to me professionally and personally.
This afternoon, we have a number of learning objectives that we hope you will agree with. My favorite is the very first one, because what we want to talk about this afternoon is that intersection of state civil protection orders and federal immigration laws. And it's an important intersection. There are a lot of ways in which we can enter that intersection, and we want to talk about all of them. We hope to help you issue spot, to talk about remedies. We're going to talk a little this afternoon about U visas and T visas and how they might impact protection order cases. We want you to understand the role that you might have in whatever role you come to us in this afternoon. And we definitely want to talk a little bit about how to make these orders enforceable so that they can really, in fact, provide the protection they are intended to provide.
So as we get started, I just want to give you a little background about immigrant women. We have lots of research on this, but just the highlights are that immigrant survivors suffer high levels of abuse by the time they come to court and seek help with protection order cases. Both the physical and sexual abuse, stalking at quite high rates, and their children are also suffering abuse. The other thing is that many immigrant survivors stay with their abusers until their immigration case progresses to the point where they get work authorization, which can take 3 months to 5 years, depending on the case type. And they suffer ongoing abuse during those times. But despite that fact, one of the things that we found is that many immigrant women don't know about protection orders when they first turn to somebody to seek help. But with good help and a support from advocates and attorneys, 81% of immigrant survivors are willing to get protection orders. 96% of them find them helpful, and that many of the many of the violations are around ongoing threats of immigration-related abuse, but they are helpful to reduce the violence. And the other thing that is really important to understand that we've learned from research, both from judges and from victim advocates and attorneys, is that courts that issue SIJS findings, U visa certifications, T visa declarations, provide language access, rule against abusers who try to raise immigration status in custody case. Those courts, even in times when immigration enforcement goes up, and even during the COVID pandemic, immigrant survivors continued to go to court to seek protection orders. So this is an area that is super, super important to immigrant survivors.
So let's get right to it. Let's talk about immigrant protection order eligibility. I mean, who's eligible for the issuance of an order of protection? Well, the answer is easy. Everybody. Everybody is eligible. If you have jurisdiction, all persons are eligible to receive civil protection orders. The immigration status of the party or the child has no bearing on the eligibility to receive an order of protection. So we do have a chapter on jurisdiction, our materials, that goes into it more detail. But basically, if you have authority to do orders of protection and you have jurisdiction over these people in front of you, their immigration status has no impact on their eligibility. And the immigrant victims and children in particularly often need greater creativity in determining what relief is appropriate for them. So let's talk about what the immigration law domestic violence definition is. It's the same as in your state definitions, except it's a bit broader. So if you're eligible under your protection orders for an order of protection or criminal laws for an order of protection under state law, then you are under federal law. And federal law has a different definition of battery or extreme cruelty, but it's very, very broad. And it includes all forms of abuse covered in your state civil protection order. So again, if you can get a state civil protection order, that applies to the federal statute. It covers all forms of domestic violence and includes threats and attempts and forms of abuse that are extreme cruelty. And it's important to remember that no physical harm or crime is required. So it doesn't have to be something that's actually a crime, because we know so many times of coercive controlling behavior that are extreme can in fact not be a crime under certain state statutes. So battery or extreme cruelty we've covered. So let me talk about what kinds of findings can we do in order protections that can help prove battery. And in these kind of cases, what we need to do is we need to make sure that we're very specific about what we're seeing. You know, if we want to make sure that we put in all the facts and that we put in the facts that we find. If it's not there, we don't put it in, but we can make a fact that this is battering under state law. This is extreme cruelty. This constitutes domestic violence under the laws of the state of whatever state you're in. So those kinds of findings are very helpful in a victim's immigrant case. Laura, do you have anything to add on that?
I want to add, though, to keep in mind that when you're trying to determine what findings you're going to make and you're evaluating the facts of the case, it's important to remember that facts that you hear have a context. So what might sound innocuous, he moved a suitcase to the door, or he put my passport on top of the refrigerator, or whatever. Sometimes those things seem innocuous, but in the context of a controlling kind of behavior and a controlling in a cruel household, they may have very specific meanings. So uncovering what does that mean will tell me more about why it frightened you when he put your suitcase by the door. Tell me more about what it meant to you and what you understood he was trying to communicate to you when he put your passport on top of the refrigerator, whatever it is. And so I think just digging a little deeper and making sure that you understand the context for the information you're being given will help you determine the facts that can ultimately be helpful and useful in a victim's immigration case.
And you're right about that. Context is always everything. Who's doing what to whom, to what effect? That's what context is, because we need to know what effect is this having on the person, and why is he doing that? So, or she doing that? So it's important to put in all the facts that you have, and put in all the facts, and we'll talk about this more later, about the relationship, who is the child's father, who's the child's adoptive father, whatever the relationship is, make sure you spell it out in your findings. And make sure when you're putting in battering and extreme cruelty, you are real specific about the behavior. If he's ripping up passports, then you put that in. If there's no physical harm, if there's abuse, but it's not physical harm, then make sure you list it out. It's an emotional abuse, and why is it emotional abuse? Is he using the children against you? Is he saying, I'm going to take the children away? We know from Leslie's statistics that immigration-related abuse is a big part of what immigrants suffer in domestic violence situations. So they will take the passports. They'll rip up the passports. They won't seek the relief that they're eligible for under law, and they will intimidate them. And it's easy to do that because a lot of our immigrants come from societies where the courts and maybe the police are not at all accessible to them. Or could also be lawbreakers themselves. So it's important that we get the message out to immigrants that we are there for them, and intimidation of them and deportation threats and immigration-related abuse is battering and extreme cruelty under the federal law. Social isolation, we see that in almost all of our domestic violence cases. You can't go out unless somebody goes with you. You can't go out unless I give you permission. Possessiveness, harming pets, that's happens way too much in our society, where pets are harmed because it's a clear message to the survivors. I can do this to our pets, I'll do it to you. And the coercive controlling behavior, which we see in probably 80% of our cases, is something to make sure you put out in your findings when you're looking at what battering and extreme cruelty consists of. So these findings are real important, and what kind of cases are these eligible for? We see in a lot of these, the ones that we don't often put in are false imprisonment. But if somebody's being kept in their home, like I had a case where the woman was actually nailed into the house from outside. He had a lock on the door from the outside. He nailed the windows shut. When he left, she could not get out. Well, that's false imprisonment. And so if that is part of your facts, don't just say, I find domestic violence there. Talk about what is it? It's false imprisonment. Stalking. We see a lot of stalking. Make sure you include that, and include all of these. Don't just put one of them down. If you see that there's sexual assault and false imprisonment and stalking and involuntary servitude because they're making them work in the family business but not paying them, make sure you put it all in there, each and every one of them that you see. Make sure you list it and name it. And remember that any attempt, conspiracy, or solicitation to commit any of these crimes is part of the similar activities. So make sure you put it in.
I would just add that we also want you to be thinking about the things that are kind of new and innovative. We're seeing a lot of inappropriate behavior around cyber stalking and cyber surveillance. And so, we think about things like false imprisonment maybe, or stalking, as being sort of obvious ones, but think about the ones that are a little more subtle, like these cyber surveillance kinds of abuses as well.
And that happens a lot with children. People will put trackers in kids' backpacks, in kids' shoes, things like that. So if it's happening to a child, then it's happening, and you should put that in your findings.
And I think it's really also important to note that these are things that, you know, as you're hearing from the judges, those of us that are lawyers should be asking for. We should be asking for this level of detail in the orders, in the findings. And we have a whole other, we'll send you a link to a webinar we did on stalking that gives you a lot of different pointers and factors and the kinds of facts that judges can find to document the stalking behavior. So that will help establish the pattern, because stalking is one of the underlying criminal activities in immigration cases as well. Judge Collins already mentioned, but I'll just say that we have materials, a brand new tool that we published today, actually, on domestic violence, involuntary servitude as human trafficking, sufficient labor trafficking for the issuance of a U visa. And we have it summarizing new materials from DHS on this issue. So it's really important to identify it and seek protection orders based on involuntary servitude and labor trafficking, as well as part of a domestic violence relationship. You're muted, Judge Livingston.
That happens at least 20 times a day. Thank you. So I have a question for you. And it's a true false question. So you got a 50-50 chance. Is the issuance of a protection order a deportable offense? What do you think? Yes or no? Answer in the poll. We like to make things interactive around here, so we hope you'll take the poll. True or false? Is issuance of a protection order a deportable offense?
This is a great group, judges. They're answering very quickly.
I actually don't see the results yet. So.
Okay, let me, we've got more than half, so I'm going to end and share. Do I have to hit share? NCJ, FCJ, folks?
Yep, go ahead, Leslie.
Okay, I've never had to do this part myself.
Well, 79% of you got the answer right. That is false. And what the point here that we want, and for those 21% of you, not to worry, that's why we're having webinars. The answer is false, because the issuance of a protective order is, Judge Collins has already told you, everyone might be eligible for it if the court has jurisdiction to issue them. Everyone's eligible if they meet the criteria in your state. So it's not a deportable offense to issue a protective order. It is a deportable offense if there is found to be a violation of a protective order. That is, in fact, a deportable offense. So it's important to keep that distinction in mind as you're considering this. Protection.
So with this,
Go ahead.
yeah, so with this, you need to know that if you violate a protection order, it can lead to your loss of lawful permanent residency and can have other immigration consequences for the perpetrator. And so a finding of a violation of protective provisions can trigger deportation. And that includes not only findings in a civil contempt case, but also in a diversion program. So if somebody comes in and says, we'll put you in a diversion program, you just have to admit that the violation of the order of protection, those findings can be used in a deportation hearing. And the reason why it's really important to keep track of this is because, and we'll talk about Padilla warnings later, but we need to make sure that when we're doing orders of protection, that we don't inadvertently get victims who are the respondents in orders of protection. So you should be very careful that victims are not charged with violation of orders issued for their own protection. I know that sounds ridiculous that that would happen, but it does happen sometimes. We still have some jurisdictions that tell victims that they are responsible for their behavior in an order of protection, and the order of protection is just against the respondent. So victim can't be charged with a violation of an order of protection. And it's important too to tell respondents about this, because if the respondent is an immigrant, then this is an added level of urgency to follow the order of protection. Because if we make it clear to a respondent that not only are you facing other consequences for violation of this order that apply in every case, but if you are an immigrant, you could also face deportation. So it's really important to be clear about this. when you're in court. So which of the following is a deportable offense? Deportable offense. A, domestic violence criminal conviction. Here we go. Here's the poll. So just fill it out.
B, I can read it. Finding in a custody case that a protection order was violated. C, a criminal conviction for violating a protection order. And D, agreeing to diversion in a protection order enforcement procedure.
And E, all of the above.
And E is all the above. Coming in, we've got about 30, 40, another minute or so. I'm looking to see when it starts slowing down. We got about 60%. And while you're filling it out, I want to let you know, see a lot of questions in the chat. If we don't, we're going to integrate many of these into our presentation. Any of them that we don't get to, we'll review the chat at the end, and we will send as a follow-up email to everybody attending. I'm sharing the results.
Okay, A class. Yes. So of course it is all of the above. So the best practices are to, when you do an order of protection, give the Padilla warnings, and don't rely on attorneys to do it. When we first started doing all these warnings, sometimes I was tempted to just ask the attorney, did you tell your client about this? Well, you can't do that because they'll say yes, but they may not have done it. And then the client will come back later and said they didn't get it. So you do it yourself. Always do it. Don't rely on counsel to do it. And make sure that you spell it out to the parties. When one party's pro se and another is represented, consider, if you can, appointing counsel for the unrepresented party. If you can, get attorneys to volunteer to represent unrepresented parties in orders protection for a limited appearance. That's a great way to do it if you don't have available them. And that's important because we know that there's a real race to the courthouse, don't we? I mean, protection orders are issued often based on who gets there first, unfortunately, especially when you don't have a lot of information available. And protection orders issued against immigrant victims are particularly harmful. And we're going to talk about why next.
So there are a number of reasons. They're harmful against all victims in things like, to the extent we're talking about, they can make it harder for a victim to gain custody of their child. It's a very powerful mechanism that perpetrators can use for coercive control. So it's not good for anyone, but for immigrant survivors, it puts them one step away from deportation. Because violation of a protection order is a deportable offense, perpetrators often who are able to get the victim to agree or to get a judge to agree to issue a protection order against the victim are often able to come back into court and convince a judge she violated the order. And so it's really important to not put an immigrant survivor in that position. When I litigated these cases, and I don't have as much depth of cases as Judge Collins did, but I think we literally went to trial on about 800 protection order cases in my career. And those, whenever I had a client where the perpetrator was seeking protection against her, I treated it like a murder case. I put on a self-defense. I did everything I could to try to keep the order from being issued against my client, which I recommend that everybody does, because it's not good. It's very dangerous for victims to have protection orders issued against them. And for immigrant victims, it also means that it could lead to their denial of an immigration remedy that is designed for them as a crime victim that they could get otherwise, or naturalization.
And we know how easy it is for something like this to happen, because when the police arrive at the scene, the immigrant may not speak English. And so the only person that speaks English is the perpetrator. And the perpetrator, as you know, can often be very calm at the scene, where the immigrant can be upset and finally, or the victim can be upset and finally feel safe because the police are there, so they can express their frustration and anger and upsetness about what's happening to them. And I don't even think that's a word, but you know what I mean? So the perpetrator will will often speak to the police and they'll offer to interpret, or if they ask a child to interpret, the perpetrator is there, they can tell that child, you say what I say. So, and they can see victims' injuries, but they can take no action. They advise both parties about protection orders because the police often do that. The perpetrator knows where the courthouse is, knows how to use the system, and can often physically get there quicker. Sometimes victims actually go get medical services, or they hide because they're worried about retaliation. So it may take them a while before they're able to actually access the court system. By that time, the perpetrator's already been down there. And sometimes the perpetrator can convince them to arrest the one. So it's always important to determine who the primary aggressor is. And there have been studies that show that survivors, when they come in, if they're charged and say, did you hit that person? They'll say, yeah, I hit him and I'll do it again. But they don't ask him, well, why did you hit him? Well, it's because they hit him in self-defense. They hit him because they thought he was going to kill him. And the perpetrator will come in and they will plead not guilty a million times over. So it's really important for the courts to determine who's the primary aggressor. Was one party acting in self-defense? Who is actually seeking the order of protection? And we know why that's particularly important for immigrant victims. There are many ways to determine that. You can look at the history of violence. I know that we can see criminal records of everybody in our system. I have access to all the court records from everybody in there. And I always tell people, when you're doing an order, if you're looking up something online and it's not out there as part of the record that the parties have in front of them, I always tell them, I'm looking at the criminal history. If you look at the offensive and defensive wounds of the parties, let's let the parties talk. Lots of times, if I just let people talk, I can figure out what's going on after a while. Look at the ability to do what's alleged. You know, lots of times they'll say that the person who did this to me, well, she did this and that. And you look at that person, you're like, don't think so. It's almost physically impossible. And look at how the size and strength of the parties, the force and violence, all the factors that you use in making this factual determination, you should use to determine predominant aggressors. And Laura, when you find somebody who is not the predominant aggressor, but is seeking an order of protection, what do you do?
Well, the short answer is I deny it. I don't grant it. I mean, I'll just put it this way. I do not ever want to be in a position as a judge of being used as a pawn in someone else's game. And so when I see the predominant perpetrator coming in, trying to abuse the court system, trying to abuse their intimate partner, and trying to, upset the natural order of things, I'm offended by that. And so I'm not gonna grant that protective order. In fact, what that person is subjecting themselves to, since I have jurisdiction over the case, is a number of orders that they really did not intend. So the unintended consequence to them of coming to ask me for something when it's clear that they're the predominant perpetrator is going to be an unpleasant surprise for them. So that's the first and foremost thing. But you have to be thoughtful about the facts, and you have to let everybody tell their story, and you have to ask those pointed questions. What happened? Who did what in what order of things? And so when you can get to the bottom of it, if your finding is that the applicant is the predominant perpetrator, then you've got a lot of remedies to literally remedy that situation.
So Judge, can I ask you both an additional question that I'm seeing in the chat that's kind of related to all this, is that there are some jurisdictions where they say they're still issuing mutual protection orders. And, or they're trying to convince a judge not to issue a mutual protection order. Any recommendations about what counsel should do? They're not enforceable from under VAWA interstate, but other, approaches that they could take.
I think it's important that you go over the statutory findings that a judge has to make, and then reiterate how harmful it is for a person who is not an aggressor, not the primary aggressor, to be as a respondent in an order of protection. And we know how harmful it is for immigrants, but it's harmful for everybody. And if you look at the facts that are related to this, and you say, and I think you tell them this is a primary aggressor case. review the pleadings, make sure that they know about the criminal record. I think you just have to point it out, and I think you have to really stress how inappropriate it is to issue an order of protection against a victim, because it really hamstrings them for future abuse down the road. When the other person wants that victim to get in trouble, it's really easy if they are named in an order of protection as the respondent, then it's easy to escalate, to get police involved, and to cause a lot of harm to a victim of domestic violence that should never have happened in the first place.
I think for advocates, you really have to compare the pleadings, which oftentimes are pretty boilerplate kind of pleadings, with the affidavits that are often filed to support the requested relief. In my experience, you will find a number of inconsistencies in what it says in the affidavit and what it says in the pleadings. That's a red flag. So advocates really need to be looking for those kind of inconsistencies. Courts can do the same thing. You have pleadings in front of you, you have those affidavits in front of you. Almost always you're going to find some inconsistencies if in fact the person before you, that's the applicant, has been the predominant aggressor. So pay attention to those kind of things. I know that these are heavy dockets. There are a lot of cases in front of us. We tend to, not have a lot of time to deal with each particular individual situation, but these are serious consequences. And so I think we owe it to them to really take the time to review the papers, to look at those pleadings, to make sure they're not inconsistent with what is in the affidavit, and ask a few pointed questions, dig a little deeper, try to find out really what happened so that you don't fall into this trap of, a mutual order, which I think is not only unenforceable, but bad law.
And let me just say, as a lawyer, what I've done the few times that maybe you end up with in front of a judge that really doesn't like the protection order process, and they're more likely you think they're going to issue a mutual order against your client. What I've done in those cases is sometimes I've just settled, or I've dismissed with prejudice, or without prejudice, or sometimes even with prejudice, and then waited because we knew there'd be another incident, and then came back on another incident in the future. Sometimes I settle but not for a mutual order. I'll take it into, let's say, the custody arena or the divorce arena and do something over there. And then oftentimes these perpetrators are going to violate. You want to if you can walk away with an order where your client isn't like getting a mutual protection order against her, that's better, because when the perpetrator violates, even a judge that is reticent in the beginning will feel very differently once their order has been violated. And you want to try to get the perpetrator into that position.
That's absolutely right. I mean, even if you decide to non-suit your case and you go over to the divorce court and get a temporary restraining order or a temporary injunction or some kind of relief over there, then you're in a better position than having a mutual protective order issued. That's exactly right. And Leslie's exactly also right, that if the court's order is violated, the judge is going to have a very different attitude about the violator at that point.
And if it's issued, I think what you can do too is, when you have further bad behavior on the part of the true offender, is you come in with a motion to vacate and file a motion to vacate the findings against the non-primary aggressor. And so file your motion to vacate and say, this was a mistake. All the facts didn't get brought out, whatever. And ask them to vacate that order against them. And maybe at a later time and date, they'll do it.
That's a great idea.
Yeah. So you just have to file it within 30 days usually. So it's very important to do the findings in cases of immigrants. There's a trend we see across the country now, and it goes back to what Judge Livingston was saying. We have very heavy dockets. I have tons and tons of cases in there, and you're very tempted to go through them as quickly as you can. And perpetrators have really found a great solution for us, and that's to agree to orders with no findings. And they sell this to victims in conferences, because they say, you won't have to testify, you might walk out of here without anything. And here we can do this one with no findings, and it'll be good for them, and all this stuff. And they convince victims to agree to this a lot of times, and they convince judges to agree to it way too many times. But no finding orders of protection are no order of protection. They're jurisdictionally not enforceable. They allow abusers to keep their firearm, which we know is one of the top danger lethality markers in the danger assessments. It increases the danger to a survivor and their children because they think they're protected by this order and they aren't. And it undermines the state laws because it's not allowed. It's not a real order of protection. And so, but it's a real trend that we've seen across the country. And don't let them talk you into it. Do findings. If they're willing to agree to an order, then say, do it. Fine. We'll do a one based on the findings. And then we'll do that. I issue these findings and you agree to the remedies, but don't do one where there's no findings. And when you do findings, make sure you put down what the existence of the relationship is, the spousal relationship, the parent-child relationship. Make sure you put down exactly what the facts are that constitute the sexual assault, the stalking, the cruelty. Make sure you include the immigrant survivor and their child or their stepchild. Children are allowable to be on orders of protection and should be listed on orders of protection, not only for their protection, but also for their immigration status, and include creative remedies because immigrants also often needs remedy, like, turn over the passports to, a third party, like their, somebody they trust, like their mother or somebody. Turn it over to somebody or give it to them, make sure that they have their papers they need, make sure they have what they need to go on with their life, make sure creative remedies can include financial remedies. In most states, you can do financial remedies such as, make sure they continue to pay for the cell phone, make sure they, continue to pay for childcare, or things like that. So be as creative as you can be. And the way to do that a lot of time is to ask the survivor, the victim, what do they need? What would make them whole? I mean, we had a case one time where the survivor had to take so much time off work because of court, and they worked for the same company. So the vacation days could be transferred from the offender to the victim in the case. So that way she was made whole with her days off work. And that meant more to her really than the money because she had kids and wanted to be able to take time off. So be as creative as you can be.
So there are a lot of traditional remedies that are really important for immigrant survivors. Things like economic relief, getting custody of their children, being able to stay in the family home and get a kick-out order against the abuser can be really important because for immigrant survivors, if they're in the process of filing a VAWA self-petition or a U visa, they could have to wait 33 months or 4 years or 5 years before they get legal work authorization. And protection orders provide an opportunity with their traditional remedies, in addition to the creative remedies we'll be talking about in a minute, that really can make a difference for immigrant survivors in terms of keeping them safe. And what's also important is that I got, and many attorneys around the country get, and judges issue, no unlawful contact protection orders. These are protection orders that are basically allow the parties to continue residing together and offer protection during that time. And I cannot emphasize in the immigrant survivors cases I've worked with how important those provisions are. They say do not molest, assault, threaten, abuse, stalk. Do not, no unlawful contact, go to batterers treatment. And I have clients who would come years later in my office and say how that no unlawful contact protection order changed their life, because he'd raise their hand and she'd raise her piece of paper and he wouldn't hit it. And that was the first time there was anything that helped reduce that. So they are very important remedies to consider. And
Leslie, if I could just say real quick, can I just add something real quick on that, Leslie? When somebody comes in and they want to drop their order of protection, that's a great remedy to suggest. Because if a person wants to say, if I want to drop the order of protection, I need him to do this, switch it to a no unlawful contact one. And then they'll keep the order and that'll protect them.
Okay. And the other thing that's really important is that custody be included. We know that immigrant survivors who seek custody, seek protection orders, seek VAWA self-petitions and U visas, in those families, the co-occurrence of child abuse drops from 77% to 23%. So it's really important. Why is it best practices for judges to address custody and visitation and protection orders?
Well, because we know that those issues exist. And if we don't address it, then how are they going to figure it out? And so it's really important for us to talk to them and take the few extra minutes it takes to say, how do you want the child visitation to go? And lots of times you'll find that the parties have an agreement. I'll drop him off at his mom's. I can do this. Or sometimes I've had people say, I don't want to see the kids at all. And so you just talk to them about it and you can figure out what's the best way for them to handle it.
I think the short answer to that question is that we do not want to literally put the kids in the middle, and we certainly don't want to put them in the middle of a dangerous situation. My sort of shortcut for that is that I don't want the kids to be in the middle of a tug of war and without some sort of an order in the context of the protective order that deals with who's going to pay what bill, who's going to provide what support, who's going to get the kids to school, and where's the kid going to sleep. If we don't deal with those things, it becomes another thing for the two of them to fight about and another source of conflict. We are in a position to solve that problem right then and there. We can do that by keeping everybody safe, particularly the children. And so it's imperative that we do that in the context of these protective orders. So, go ahead.
There's a question I want to answer, but just before we finish delving into custody, somebody said, are consents without admissions useful for protection orders? Or not? I think it's an interesting point, and there are ways. So legally, I'll just do the law professor part of this and say that when a victim fills out a protection order request, they're doing it under oath, and protection orders are civil cases. Therefore, if the perpetrator is willing to agree to the issuance of a protection order, then the judge can base the protection order on the uncontested affidavit of the victim, and you have a viable way to get an enforceable order without having to have an admission. But admissions are also good. I just wanted to address that. Didn't want it to get away from us.
No problem. Well, good for law professors to address such interesting questions. Good for judges to talk about what's relevant and what's not relevant. And so this question comes up a lot, whether or not immigration status is relevant to custody. I think the answer is that it might be and it might not be. That's a nice classic law professor answer too, right? It depends. Certainly a judge answer. It depends. Well, it depends on what the issue is. If the issue is who's the primary caregiver, then the immigration status is irrelevant to that. When it's time to figure out who the child is going to go to when sick or sad or depressed or needs help, and that person's immigration status then of course is irrelevant. It might be relevant to, whether or not a crime victim presents some sort of evidence about immigration related abuse or the power and control that they might have suffered, whether or not they're filing or maybe withdrawing immigration papers, issues related to deportation, a history of violence. It might be relevant to that. Certainly not relevant to who's taking care of this child, who is the primary parent in this household, what's been the division of labor, and who's doing what in the household related to the child. That's what's important in a custody determination, not immigration status. And so I think we have to kind of keep that in mind. There are some myths and facts about this sort of thing. One of them is that deportation is imminent. Let's get realistic here. What in our governmental system is imminent? Everything takes a long time. It takes a long time to get relief. It takes a long time to ask for relief. It takes a long time for them to act on the relief they provided. I mean, it's not almost never imminent. And that I think is typically a myth that we often dispel, but it's one that we hear a lot. Why? Because it's one of the kind of tools that perpetrators use to exercise control, to instill fear, to inspire mystery about the process to someone that's uninitiated, and they use it over and over again in inappropriate ways. But it is, in fact, a myth. Parents likely to flee the U.S. with a child. not so much. The facts are really, as we put up here on the slide, US citizens and lawful permanent residents are more likely to flee with children than others we have found, and that's the data talking. That's not just my anecdotal experience, although my anecdotal experience matches the data. A parent has no likelihood, therefore they're going to do X, Y, or Z, including fleeing or anything else. It's just not really borne out by anecdotal experience or the data that Professor Orloff and her colleagues have determined to be the real truth in this situation. So it's important for us to sort of dispel the myths, pay attention to the data, pay attention to the actual facts, so that we can help immigrant victims avoid the trap that they often fall into when they are persuaded about these myths.
So we're going to do another poll. Why are economic protection order remedies particularly important for immigrant victims? Do we have the poll? No, guess not. Yes, there we go. And there's a question that came up maybe while we're looking at this poll about how there's somebody saying that sometimes they're running into some judges in protection order cases that are not willing to issue vacate orders against homeowner abusers.
Yeah, that does happen. And so I'm not sure why we should reward abusers who are committing criminal acts or abusive behavior with that sort of behavior. I think what the best that I've seen, if you're working with a judge like that, is to ask for a temporary order. And so, say, Judge, I know you don't want to order them out, but she's got nowhere to go, and why should she, suffer, blah. And so say, we'd like temporary residency in this facility for 30 days or 60 days to give her time to get someplace out, because there's this, I don't know why some judges refuse to do that, but I know that happens. So I would maybe put it a little different and just say, we just need it temporary. We don't think he should be warded for his bad behavior. And so we'd like her to be able to stay there for 30 or 60 days until she can find someplace to go.
Yeah, and then the answer on this one, if I can, is that the answer is all of the above, and that these are, victims have to wait to get work authorization, they can't purchase health insurance, and they have limited access to benefits. So economic remedies are super important. So now we're going to turn to some creative remedies.
Do that, Leslie. We did get a question in the chat about some immigration lawyers advising their clients to drop protective orders.
There's no reason for that. I mean, immigration lawyers should not be doing it. They should take this webinar, turn to our materials on the website, send the immigration lawyer to us for technical assistance, because there's no reason that for an immigrant survivor getting a protection order is a bad thing at all. So let's turn to we've got about 10 minutes to go, and we want to talk about some creative remedies, and we want to talk about U-Visa certification in the context of protection orders and SIJS before we end. So
in 10 minutes, I'm going to go very quickly through some of these then and simply say that the more creative remedy you can suggest to the court and the more creative remedy you can ask the court to create, you're going to see some incredible benefits to your victim clients. It's going to stop future abuse. It's going to curb some of these myths. It's going to prevent bad behavior, and it's going to provide some real practical relief in an economic way that's very real to your client. And so I'd encourage you to review the materials, both these and the slides, but in addition, the materials that we're providing at the end of this webinar about specific kinds of things you can ask for. I'll just say a few: child support, who pays the mortgage, health insurance, other kinds of financial relief, things that are really practical, things that are everyday, things that are going to make a difference between eating and sleeping today versus, waiting down the road for some sort of relief. These economic remedies are really, really important so that they can prevent people from feeling trapped and like they have to go back to the abuser to survive. So I'll stop there.
And I'll just add at the end of that is that they also can be used to stop immigration-related abuse. Perpetrators can be ordered not to turn their victim into DHS or IRS or immigration or welfare. And these orders are enforceable, and I've enforced many of them over my career. Here's some more on the economic relief.
So special immigrant juvenile status is a topic that we could spend days on. So let me just tell you that you do have the authority. We are the gatekeepers through special immigrant juvenile status. So you are the one who can make those findings. You're the only one that can make those findings. And so if a child is dependent or on you, or you can legally commit that child to the custody of agency or individual, then you have jurisdiction over the child for the purposes of this act. And then you must find that reunification with one or both parents is not viable due to the abuse, neglect, abandonment. And we do that all the times when we place custody with one person. We are finding that custody is not viable with the other person. We also find that their best interests aren't being served by being returned to their country of origin. And that's a finding we make when we make any finding about the placement of a child, because we are saying the child should be placed here. And that in effect says it's the best finding, the best interests are served by not being placed there. So it's not super complicated, but that's what we have to do. And it's important to remember that with these SIJS cases that there's a time limit on them. So you have to move very quickly on this because they lose jurisdiction once a child is age of majority. So in CPOs, they can be done, in child protection orders, they can be done. And then let's go on to the next slide. So the children must be that age. You don't grant immigration status through doing special immigrant juvenile status. You just provide evidence for the immigration case which once it goes past us, then they will continue to review the case. So you're just doing evidence based on what you hear. And it also gives the abused parents. So make your findings, be specific in your findings, and cite your state law. And that's the really short short version of SIJS. So please look at our material about that.
And I'll just say 1 second that we have a bench book on special immigrant juvenile status that has a whole chapter on protection orders. So you can look at how you would approach as a judge or as a litigant or representing a child in a protection order case to get SIJS findings.
We did get a question.
Not complicated, but it's really important for judges to know that they have an important role and they should use it, and they have to act quickly on those cases.
We did get a question in the chat about a judge denying an SIJS application because of not being able to make a finding on abandonment. I would encourage everybody to remember and cite all the law that it requires abandonment by only one parent. It doesn't have to be a total abandonment circumstance, and sometimes judges get hung up on that. And so even if one of the parents is in the child's life, if the other one has abandoned, it's one parent. So the best I can tell you, I think, is to review the bench book, look at the chapters, look at maybe some old recordings of webinars where we go in much greater detail about these issues, and maybe reach out to Professor Orloff and her colleagues to get more technical assistance related to these issues. But the law says one parent, not both parents, must abandon. And so
and abandonment is at a point in time. It's not, you're not predicting the future. You don't need to say that the person will never be back in this child's life. Abandonment is a determination at that point in time.
Okay, so let's go on to U visas.
all right, very quickly, let me just talk to you about U visas in the few minutes we have remaining. The requirements are spelled out very clearly. We have them here in the materials, but just very quickly, in order to get certification, victims have to be helpful in detecting, investigating, prosecuting, or convicting or sentencing a crime victim. I'm doing this so fast, I'm going faster than I possibly could, but the materials are fantastic, as is the technical assistance you can get from Professor Orloff's materials. There is a whole list of qualifying activity. The list is long. You will see it here, but these are general categories. And I think the real point we want to make is if it sounds like, something related to prostitution, that's going to work, right? The more specific you are, if it doesn't fit exactly into torture, but you think it's pretty close to it, allege those facts, that might get you there. So be specific and don't be limited by the list. It is long, but probably the activity that you're encountering will qualify. More on the qualifying criminal activity. I want to go really next to kind of some things that we want to speak to, particularly to those of you that are going to be signing the certification form. You may need to tweak the form. If you need to cross something out, you can do that as long as you initial it. For example, when I, as a judge, am being asked to sign a U visa certification, it says here, based on investigation of the facts. Well, I'm a judge. I don't investigate facts. I make findings about fact after evidence is presented under oath in an adversarial proceeding. I don't investigate. So I'm going to cross that out. I'm going to put my initials next to that, and then I'm going to sign it. Down here at the bottom, I certify that, if the victim unreasonably refuses to assist in the future, I'm not doing that as a judge. I'm going to cross that out. I'm going to initial it. We've determined that USCIS will appreciate these crossouts as long as you initial them, because they appreciate our role as judges and in not being able to use that language. So don't hesitate to make the form your own and make it say what you needed to say in order to feel comfortable about signing that certification. We got about 2
And I'll
minutes
just
left.
say that as to the trafficking, it's important to note, we have slides here for it. Judges can not only in protection orders sign U visa certifications, but also T visa declarations. There's a lot of different kinds of judges and magistrates who can sign them when they detect criminal activity. How commonly judge, so in terms of the kind of helpfulness that you see in courts, I know you both sign U visa certifications all the time. And
Yeah.
so what kind of helpfulness are you seeing in court that is the basis for those certifications?
Helpfulness can be something as simple as coming down to court and getting, requesting an order of protection. I look at helpfulness as, there's low hurdles and there are high hurdles in a race. The helpfulness is a low hurdle. All right. You come down to the courthouse, get an order of protection. You come and testify for the order of protection. You call the police to get help with that. Helpfulness is a very common thing. If the case comes before you, chances are there's helpfulness there.
Think of it this way. Judges cannot do what they do. We cannot evaluate the facts. We cannot judge credibility. We cannot make findings without some evidence. We get that evidence from those of you who come to court and present it to us. That's helpful. I can't do what I do as a judge without you doing what you do as an advocate. I can't do what I do as a judge without you as a lawyer presenting those facts, arguing those cases. I can't do what I do as a judge to make those findings and judge credibility without witnesses. So when someone comes to the court and goes to all the trouble to be courageous enough to come and tell their terrible story about all the abuse they've suffered and what's happened to them, that is helpful, because that is the first step in a court order being issued, potentially dealing with violations and contempt down the road, and on the road to finding justice for the people in our community who need protection. That's helpful. And that's all you have to do to make me sign that form and determine that helpfulness is present.
That is a great point. So thank you, judges. There is a lot of information on the website that we're going to share with you. This has been an overview. There's more information in the slide deck online. We encourage you, Judge Collins talked earlier about the National Judicial Network. If you're a judge, we encourage you to join us in the National Judicial Network, but we also have communities of practice for family lawyers, victim advocates, and law enforcement prosecutors and system-based victim advocates. So please consider joining some of these for ongoing learning opportunities. We have resources that we will distribute on U visa certification and SIJS and protection orders to all of you after the webinar. And we, as you heard the judges talk about, offer technical assistance. So please don't hesitate to call us for more. We're trying to give you, I know this was a quick overview, but we wanted to give you kind of a high level taste of what some of the real serious issues are and the opportunities to make protection orders as effective as they can be for immigrant survivors and all the survivors that come before your courts, and that those of you that are lawyers and advocates and other professionals serve. So thank you so much for joining us today. And thank you to the judges for presenting and to NCJFCJ for hosting.
Thank you, everybody.